Our next speaker is Lee Hollis. Lee is a trial lawyer with Lightfoot Franklin White in Birmingham, Alabama. He is a cum laude graduate of Washington and Lee University and a graduate of Vanderbilt Law School. Lee handles big cases. He won a $70 million jury verdict for a major chemical company in a breach of contract case, a defense verdict in a case involving 15 deaths and 15 injuries arising from a bus crash, defended a Fortune 10 company in a class action alleging infected endoscopes, has handled aircraft, breach of contract cases, automobile dealer litigation, and the list goes on. Please join me in welcoming Lee.
Well, Ellis asked me to speak on ethics this afternoon, and I looked at my watch and I'm like, it's 2:30 in the afternoon. We're talking about ethics and privilege issues. So on the way over here, I stopped. If anybody's tired, I got a little Red Bull. We can pass it around, and I might need some to get through this myself. It's right there. This topic is one that is full of pitfalls, and I'm going to try to be very practical in some things that I've learned over the years, because I didn't do a lot of insurance defense work, and I started doing work coming in for excess insurers and high exposure cases, and I learned this landscape a little bit the hard way, and I thought I'd share some of that. The paper that is in the materials details a lot of these privilege issues, and I have to give credit to Dawn Krigston, who's in the audience from Iron Shore. This is a paper that we co-wrote together with Jonathan Goodman from GE, and we did a panel discussion on it at the DRI Toxic Tort Seminar in New Orleans in February. So this is a little bit of a retread of that. But, all right, the basic thing we've got here is a claim against an insured. They put their carrier on notice, and the carrier has a duty to defend. They hire a lawyer, right? So everybody's basically familiar with that situation. Just to get the context here, the insured has some important duties. They got to notify the carrier, and they have to cooperate in the defense. Some of those things are in common law or statutory rules governing the conduct of the insurer, and everybody's got to cooperate in this situation. That's the idea, and we're going to talk about how that becomes a challenge. Typical policy provisions that are in these things require the sharing of information, share the complaint, the lawsuit, the demand letters, allow the insurer to get whatever information they need, cooperate in the investigation and the defense and the settlement of the case, assist in enforcing rights against others like subrogation, and don't take on an agreement to pay money without the consent of the insured. Those are there to protect the insured's interest in this situation. And everybody knows if you don't cooperate, that could lead to a loss of coverage. So we want to talk about here some of the quandaries that we have. I'm going to skip that one. So we got inherent conflicts in this situation. Questions arise. First of all, who is the client? And this will be a theme that I'll talk about throughout. You know, you've got an insurance company that calls you all the time to jump into cases. You know them, you have a relationship with them, but you are asked to insure company ABC or defend them. Well, who's your client? Obviously, it's company ABC who's the defendant. You've got to keep your eye on the ball there because there's going to be tension, as we talk about, in this relationship. There are privilege issues that come up. Can you share information with the insurer, confidential attorney-client privilege type information? Who's in control of the strategy? Who's in control of the settlement? How much information do you provide? And are you protecting the interests of the carrier or the interest of the insured? So all of these things come up, and we'll walk through them a little bit. As I was looking into this issue, I was actually a little surprised about how varied the privilege rules are. Most states haven't even decided this issue clearly on the privilege of communicating information to the insured and the insurer. Those states that have decided it have what they call the dual client theory. Both the insured and the insurer hold the privilege just like it was one client. That makes that fairly easy. The minority rule in some states is that only the insured has the attorney-client privilege with the lawyer. But in those states, they usually recognize a common defense privilege. So if we have a common interest in defending the case, we can share that information. The trick becomes if there is a dispute between the carrier and the insured. In some states, you have that privilege, but in a later litigation over coverage, say, that privilege information can be used. So the lawyer has to think about, what are we sharing? What do we have a duty to share? Could this be used to affect coverage later? And you got to think about that when you're sharing information. I was surprised to find that in some states, if you just have a reservation of rights letter, there's no privilege, because some courts deem that to be a conflict of interest from the outset. So that would mean there's no privilege. You've got to be very careful what you communicate, or you're going to be waiving the privilege. So the point of this is you need to know the law in your jurisdiction so that you know how you can communicate with your client and the insurer. So I thought we'd talk about some examples. These are practical things that have come up in my experience, in my firm's experience. One time we had a large publicly traded company who had a big piece of litigation across the country. They had the right to select counsel, and they had a pretty significant SIR of about $20 million, I think it was. Well, that was an eroding SIR, and once that's exhausted, a couple of $100 million worth of insurance kicked in. Well, those excess carriers, this one out of Bermuda, asked me to get involved to evaluate the situation. I think I slipped over a slide. This is what they call associating counsel. So the excess carrier doesn't have the duty to defend, but they can retain their own lawyer to jump in, evaluate it, make sure they're getting a good picture. Because one tension is the lawyer for the insured says, well, pay $100 million. I want this over. And maybe the case isn't worth that. So they want to get an honest job. All right, so I came into that situation, and naturally I go to the lawyers who've been handling it, and I say, send me some information. I want to talk about your analysis of the liability and the exposure. And they're like, no. And I said, what do you mean, no? And they said, well, there's a reservation of rights letter, so you tell the carrier, you drop their reservation of rights, and I'll give you whatever you want to know. So they were trying to blackmail the carrier into giving up their rights in order to get information about the case. As you can imagine, that was a problem. So that's when I first started looking at this issue. Well, we drilled down in that particular jurisdiction. It wasn't a waiver. And we had to convince them that they could share this and it wouldn't be a waiver, and we managed to get through that. But that's a situation of that carrier using that clearly as just leverage to try to get more than they bargained for under the policy. And that reminds me of one point that is very important in these situations is you've got to make very clear your role. And I kind of teach my lawyers in my firm that are new to this work when they come along, because they hear, oh, I'm doing something for AIG, for example. And they're thinking that's a client of ours, and they're thinking that's the client. And I've got to go to them and teach them so that when we go to that lawyer who's been representing the defendant and the defendant, the first words out of my mouth if I'm in that role is, I'm retained as additional counsel for the insured to appear for the insured. I do not represent the insurance company. They might have coverage counsel. You've got to make sure they don't think you're just a Trojan horse or wolf in sheep's clothing trying to get information so the carrier can deny coverage. And so you've got to build that trust. Another situation could be if you're defending the case and you uncover facts that can affect coverage. We all know sometimes that's in the eyes of the beholder. And is a series of events separate events that each triggers a different deductible, say, under a set of policies? Or is it one long event that has one deductible? Insurance company wants it to be lots of deductibles. Insured wants it to be one deductible. So that puts you in a difficult situation vis-a-vis the insurer who hired you and the insured you represent. So that brings up the point of coverage counsel. what I try to do is make sure the insurer has coverage counsel if there are any of these kinds of coverage issues, and the insured does. If it's a big company, you're defending, say, they almost always do. If it's a smaller mom and pop type operation, they may not. And I always try to get them in the hands of someone who can look at those things, because I try to put blinders on. I try to say, I don't want to deal with the coverage issues. I don't want to know. I want to fight the enemy. So you've got to be aware of that, though, and think about, is this going to affect coverage? If you don't have a coverage counsel, get you out of it if you can. But your duty of loyalty is to the insured. Sometimes you're going to have covered and uncovered claims. For example, a negligence claim is covered, but an intentional tort type claim isn't, say, under this policy. So here's the tension. If they go to a verdict and it's a punitive damage award based on wantonness that's not covered, insurance company doesn't have to pay. If it's a negligence verdict, insurance company does pay. So you have some tension there. What's in the best interest of the carrier? What's in the best interest of the insured? So again, you got to put those blinders on. I try to keep it pretty simple. Of course it is in the insured, my client's best interest, to get the punitive damages count out. Of course we'd rather go to trial on negligence than wantonness. But you got to realize that those potential conflicts are there. Hammer letters and bad faith. This can be a real prickly situation for the outside lawyer, because, again, they have a relationship with the carrier, hire them all the time, and then you've got a situation where the client's saying, I want this case settled. I paid my premiums for years, that's why I have it. I've got a policy limits demand, pay. And then the insurance company's going, oh, wait a minute, we've evaluated this, we think it's defensible, or we think it's worth 1/10 of our policy limits, we're not going to pay. So what do? Again, I like to take myself out of that if I can, and you have another lawyer who writes a letter to the insurance company, hey, we've got a policy limits demand, we'd like you to settle this, but if you don't, and there's a verdict above the coverage, you're on the hook. It's very difficult for me to write that letter to my insurance company that hires me a lot. I've had to do it, and my partners have had to do it, but you've got to be aware, you've got to look out for the interest of that insured, and if the insurance company wants to take the gamble, they're big boys and girls, they can evaluate whether to take that gamble. And at least in our jurisdiction, plaintiff lawyers have figured out this bad faith trick, and they are, in essence, trying to collude with the insured. Hey, we got a policy limits demand, we want your carrier to pay it. If they don't, we're going to come after everything you got unless you assign me, plaintiff's lawyer, that bad faith claim and let me go after your insurance company and get more money. And that can be tempting to companies that if exposed and might get shut down. This is their whole livelihood. And we've seen situations where they agree to that. So you've got to be aware of that tension. You've got to advise your client, and you've got to make sure the communication with the carrier is clear. The settle or defend issue is a big one. For example, it's a defensible case, but it's embarrassing. And the company says, settle, I don't want a bad PR. I don't want a headline to read that something bad I did caused something bad to happen. I want this to go away. I don't want my witnesses tied up in depositions. Make it go away. Well, that's not insured. Their convenience and their public relations. That's not an insurable thing usually. So what do? That's where you want to, again, communicate. Sometimes the carriers, I know we talked about this in February, the carriers will get the brokers involved, get the underwriters involved, help the insured, hopefully not you having to do it, help the insured understand, here's what you bought, here's what you paid for, and it doesn't cover that, and we're doing something that's very reasonable, and try to get them on board. But that's a tension you've got to deal with. And one of my partners had a situation that was kind of interesting recently. The type of claim at issue, I don't know what it was exactly, had a higher level of proof. They had to be found guilty of intentional conduct in order to have a certain type of recovery. They had had a big SIR with a defense cost that they had paid out $2 million. If they went to trial and were only found negligent, for whatever reason, they were able to recover their attorney's fees from the other side. And if they were found guilty of intentional conduct, they couldn't. Well, the insured wanted to go to trial because they thought they would get a negligence finding and get their $2 million worth of attorney's fees back. The insurer said, no, I want to settle this case and cut off the defense costs. And they had a tension there. And so they had to work through that. Again, you are representing the insured, and you've got to look out for their interests, and the insurer can make that decision if that's their right under the policy. So I want to just sum up some of the takeaways to remember when you're dealing with these situations. Most importantly, build trust from the outset. Communicate with everybody. Let everybody know what hat you're wearing and what hat you're not wearing. Keep coverage issues out of it. Don't ever go there. Know the privilege rules so you don't step in it there and give up something or waive something. Keep your eye on the common enemy. Don't have a circular firing squad where everybody's shooting at each other. Focus the guns out at the enemy, and everybody has the common interest of beating the case or reducing the exposure. Communicate, communicate, communicate at every step of the way, and remember that your client is the insured at all times. Thank you.